Okay.
Good morning. Are you Shaniqua Diane Washington?
Yes, ma'am.
And Ms. Holmes, will your client waive the formal reading of the motion?
Yes, Your Honor.
Ms. Washington, in cause number 24, DCCR 2370, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation August 26th of 2025 for the offense of theft of property with previous convictions. And that was a deferred probation for 3 years. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count 1 alleges that you committed the offense of failure to identify with intent to give false information on October 4th of 2025. Is that true or not true?
Yes, ma'am.
True or not true?
Yes, true.
Thank you. Count 2 alleges that you failed to report as directed to the probation department in October of 2025. Is that true or not true?
True.
Count 3 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true? I'm sorry?
True.
Count 4 alleges that you were at a location other than your residence at approximately 1:23 a.m. October 4th of 2025. Is that true or not true?
True.
Count 5 alleges that you failed to provide verification of completing the theft prevention class. Is that true or not true?
True.
Count 6 alleges that you are behind in your court-assessed fees. And is that true or not true?
True.
Right. Did you enter your pleas of true to counts 1 through 6 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're all actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've reached with the district attorney that you'll be waiving or giving up any right to appeal? So it looks like the agreement is for me to continue you on probation. There would be a 90-day jail sanction with credit for any time that you've been in custody on the motion, and that I would extend it for 7 months. 7 months is a bit of a random time frame. What's the reason for 7 months? Usually it's
We worked out 7 months because that's about the amount of time she has missed
okay.
because of inaction or.
Because she was just placed on probation in August.
All right.
So it brings her back to her original sentence.
I think what I would rather do is you go ahead and do the full year. I appreciate Ms. French being generous with that, but I think if you didn't show up, you don't necessarily just get to back where you were. I think there needs to be a little further sanction than time served and getting back where you were. So I understand that's the agreement, but I can extend. It's up to me to do that regardless of any agreement. So that is what my intention will be. I'm going to make a notation that
Could be 1 year.
Yeah.
Mhm.
extended a year. State tenders number 1.
No objection.
It's admitted any evidence that Ms. Washington's not competent.
No, Your Honor.
All right, Ms. Washington, you're getting a great opportunity today. I'm going to find that you entered your pleas of true to counts 1 through 6 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation. But I'm going to follow the agreement with the exception of what I said as far as how long I'm going to extend your probation. I'm going to continue you on probation. I'm extending your probation by 1 year. I'm ordering that you serve 90 days in jail as a sanction. You will only receive credit since you've been in custody on the motion to revoke your probation. I don't know how much you have, but you'll receive credit for that. And then it sounds like you'll go from here, maybe down to misdemeanor court to take care of that other case.
Yes, ma'am.
You did not get off to a good start. I want you to understand that this is your second chance here and that you will not get a third. So if you violate probation again in any way, you're going to be back in here and you'll be looking at being revoked and going to prison. Do you understand?
Yes, ma'am.
All right. I'm handing you the trial court certification that shows this was an agreement that I followed. So you have waived your right to appeal. All right. Good luck to you, ma'am. You can go back with the bailiff. Thank you, Mr.
Yes. I'm gonna check with Mr.
So we're just waiting on
That's
Mr.
just
Bass.
so you're on. That's all you're on.
Oh, got it. Signing that. He's free to go back.
Oh, it's Miss on here. So.
Sorry, I didn't see that earlier, y'all. You're taking him back a while back. Kaylin Thornton.
Bring to the lesser.
Thank you, ma'am. This is Mr. Coleman's Kaylin Thornton. Good morning, sir. Are you Kaylin Thornton? And will your client waive the formal reading of the indictment?
Yes, Your Honor.
The state selected to proceed on the lesser included. Instead of the aggravated promotion of prostitution, the state's proceeding on a promotion of prostitution under 4303 of the Penal Code.
43.
This is a critical legal moment before final sentencing. The court orders a pre-sentence report. That means the judge isn't fully convinced yet and wants a deeper look into the defendant's background. This report can make or break the deal. Do you think he deserves probation or prison time?
43.
Oh, the of the Penal Code. It makes it a third degree as opposed to the first degree that the aggravated promotion of prostitution is.
Thank you. And will he waive the formal reading of the indictment as?
Yes, Your Honor.
All right. So, Mr. Thornton, in cause number 26, DCCR 0220, the state's elected to proceed on the lesser included offense of a third degree felony promotion of prostitution from November 15th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
And because you did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated. You'd be on probation for 10 years. There would be a $1,000 fine. You would be required to follow all of the rules and conditions of probation, including remaining away from the Northridge Manor Apartments at 4155 Maida Road in Beaumont. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Thornton's not
No,
competent?
Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentence. Based on the nature of that plea agreement, Mr. Coleman, what's the state's position with regard to a bond pending or bond reduction pending pre-sentence report?
The defendant shows to be a 25-year-old with no criminal history. However, there are some circumstances related to the underlying offense. I don't know if the court is. There was some violence alleged with regard to the underlying offense. Just for the court's information, we would defer to the court on that, but I just want to make the court fully aware of kind of.
And Your Honor, we are asking if the court would consider a reduction. Mr. Thornton has no intention of returning to that property. He will.
Where would you be living when you're released, Mr. Thornton?
2118 Avenue B.
That's in Beaumont.
Yes, ma'am.
So what I'm going to do pending sentencing based on the nature of your plea agreement, Mr. Thornton, is reduce your bond in your case to $2,500. If you make that bond, at least pending sentencing, I'm going to order that you wear a GPS monitoring device. That'll make sure that you're following all of the rules. You're not going anywhere near
Maida.
the apartments. Is it Northridge Manor?
Yes, ma'am.
So don't go anywhere near those. And if you do everything you're supposed to between now and sentencing, then I'm not necessarily saying you'll have to wear that while you're on probation or for very long. But if you make that bond while the case is pending, I want to make sure that you're following all of those rules. It's very important if you make that bond, a couple of things. In addition to getting that GPS and staying away from the Northridge apartments, you're going to get some documentation today from probation. If you are released soon, then the very first thing you do is go to probation so they can do that pre-sentence report. If you don't go and don't follow through with those appointments, then you run the risk of me not accepting the plea agreement. Things could be worse. Do you understand?
Yes.
Also, if you are arrested for anything between now and when you come back for sentencing, you run the risk of me not accepting the plea agreement. Okay?
Yes.
All right. You can go back with the bailiff.
And just like that, the deal is hanging by a thread. One mistake, one violation, and this entire probation agreement could collapse into real prison time. The question is, will he follow the rules, or is this just the calm before a much bigger fall?